Welcome to Legally Agile with Chris Werner.
There is a narrative circulating right now that the AI regulatory environment in the United States is getting simpler. The federal government is pulling back and clearing the field, and there's this idea that organizations can step back and take a breath. I want to tell you why that narrative is absolutely wrong and why companies that rely on that narrative are in danger of making one of the most consequential mistakes that they can make. The AI regulatory landscape isn't simplifying, it's fragmenting. And that fragmentation is significantly more difficult to navigate than even a single complicated regulatory structure from one entity. My name's Chris Werner. I'm a business attorney and advisor, and I work with companies to design AI governance frameworks that can meet the ever-changing regulatory environment and are designed to be robust enough to not only be effective today, but effective down the road as things change in potentially unpredictable ways. Today, I want to talk you through exactly what's happening with AI regulation at the federal level, at the state level, and internationally. And I want to give you a framework for thinking about that clearly and tell you what your organization should be doing right now to address those issues. This isn't going to be a survey of every single law. This is a snapshot in time. So keep in mind that I'm recording this in early June of 2026. In a few weeks, any specific law that I talk about may be different, and that's kind of the point of this. So this isn't a survey, but instead it's just a practitioner's guide of the landscape and what it means to you and what your company should be doing right now to prepare for it. So let me start with the federal picture. This is where most of the noise is coming from right now. In December of 2025, the Trump administration signed an executive order that directed the federal government to identify and challenge AI state laws that were what they said inconsistent with national policy. The Attorney General established an AI litigation task force. In March of 2026, the White House released a framework calling for federal preemption of state AI rules. The stated rationale of all of this was to reduce the regulatory fragmentation and keep the U.S. competitive with AI development. On its face, that sounds like deregulation, and less regulation seems to mean fewer rules and more flexibility. Here's the problem with that reading. Federal preemption of state AI laws is not the same as eliminating AI regulation. It's a fight about who gets to regulate, and that fight is also ongoing. It's being contested right now, and it's unresolved. So the executive order didn't instantly eliminate state rules. It just drew them into question as to whether they're going to be enforceable and stand up long term. But in the meantime, unless and until a court puts a stay to any particular rule, many of those state laws are in force while this federal preemption fight is going on, and your company is likely subject to some or all of these state rules. So you still have to pay attention to them right now, even though there's an executive order that indicates that maybe these will go away some point in the future. So let's just talk about some various state laws. Illinois, they have been very active. They have an AI disclosure requirements for certain employment decisions, and that took effect January 1st of this year. Texas has enacted comprehensive AI rules, the TRIGA framework. That was also effective as of January of 2026. Utah has AI disclosure laws that are in force right now. California obviously has been active, and they have transparency requirements for frontier AI systems. Colorado has been in the news. They've revised their laws, but they still have laws that are in effect referring to AI. The original Colorado law was a comprehensive framework. It's been replaced by a narrower statute that was signed in May of 2026. But there's rulemaking that's still going to follow. And even though it doesn't go into effect until January of 2027, there could be lots of changes even before that. These laws exist and they are in place right now or about to be implemented. The executive order doesn't make them disappear. And the legislature in each of these states can adjust and change their rules even after they're enacted. The second place that gets less attention on the regulatory front, even if the federal government succeeds in its preemption of some state AI laws, and that legal battle is going to take years, there are existing federal laws that are not going to disappear. And these are federal laws that aren't specifically for AI, but they're being applied to AI laws. So, for example, privacy laws, anti-discrimination laws, consumer protection statutes, securities regulations, all of these are being applied to AI tools today. They don't need specific new AI regulations or rules to be passed. They are already being used. For example, the FTC has signaled an interest in AI-related deception and unfairness. The EEOC has published guidance for AI in employment decisions. And the SEC has been taking a very close look at AI-related disclosures especially for publicly traded companies. So the regulatory environment for organizations using AI is not less complex than it was a year ago. In fact, it's more complex. And now you have an active federal versus state fight that's going on. That's layered on top of existing applicable laws, and that's also layered on top of a rapidly evolving and robust international framework. So the organizations that treat the deregulation narrative as permission to just slow down or stop their governance work are going to find themselves significantly behind and exposed down the road. Not because they broke any rules, but because they stopped paying attention to the landscape as it was evolving. So I want to give you a framework for thinking about this clearly. So the regulatory reality that your organization is operating under has three distinct layers, right? And you need to understand each of those three layers to know where your exposure sits today. The first layer is existing law that's being applied to AI. This is the layer that doesn't get a ton of headlines necessarily and is not as interesting because there aren't new rules, but it's also because of that, the layer that most organizations pay the least amount of attention to. However, it is the layer with the most immediate potential exposure for your company. You don't need a new AI law to face potential liability under many of the existing laws. You just need a government agency that's willing to apply the existing law to a new set of facts. And that is happening right now, and it's very active. So if your organization uses, for example, AI in hiring or in promotion or termination decisions, you already have exposure under federal anti-discrimination laws. The EEOC has been explicit that Title VII applies to AI-driven employment decisions. States are also involved in this. Illinois, for example, has the Artificial Intelligence Video Interview Act. And that's been enforced since 2020, which most people are surprised to hear. And it requires consent and disclosure when AI is used to analyze video interviews. Many other states have AI hiring and employment-related laws on the books right now that you need to be aware of and you need to be following. Another example, if your AI collects and processes personal data, you've got the GDPR, if you have any EU exposure to your user base. You also have California rules on biometric privacy laws. Illinois has a biometric law, the BIPA, that's one of the most litigated rules in the country right now applying to AI systems. And the BIPA cases already have produced some of the largest privacy settlements in US history. So those rules are in place. What about if your organization uses AI related representations to investors or customers? The output capabilities of your AI, the security of your AI infrastructure, and the fairness of your audits are all potential securities laws issues or consumer protection law issues. Um, those things exist right now. The SEC has brought enforcement actions related to AI washing, meaning companies that are over-promising their AI capabilities in ways that mislead investors. Um, the practical implication of all of this is that before you get into AI-specific regulation, you should be aware of the layer of existing law that's being applied to AI right now. Conducting an audit of that is almost always an extremely productive exercise for companies, and it will reveal exposure that can be immediately addressed if you get it right. So once you look at the existing laws as they're applied to AI, then you have to consider AI-specific laws, and these are usually state laws since we don't have a federal legal scheme yet. And it's a patchwork of laws that isn't going away. So regardless of what happens with federal preemption, your organization needs to understand these state laws. As I said earlier, the federal preemption fight is going to take years to play out. And in the meantime, these state laws are on the books and enforceable. Um, if you build your governance system to the highest standard right now, it's not over compliance, even though things could change. So, for example, Colorado's law changed recently. It was much more comprehensive and they watered it way down. But building to the highest level is actually an advantage because if you get it right, the strategy will mean that you don't have to rebuild as laws change all the time. You're looking at first principles, not building to specific laws or regulations that are in place. So let's talk a little bit about Colorado because it's one of the most instructive case studies of this kind of the flux that I'm talking about here. So Colorado passed a comprehensive AI anti-discrimination law in 2024. It was one of the first of its kind in the country, and it was extremely comprehensive. The original law would have required risk management programs, annual bias reviews, and impact assessments of high-risk AI systems. By May of 2026, under pressure from the industry, from the federal government, and from the governor of Colorado, the Colorado legislator dialed that way back. They repealed their law and replaced it entirely with a much narrower notice and transparency framework. And that was focused on automated decision-making technology. Has a new effective date of January of 2027, and there's still rulemaking to come. So we don't know exactly what that's going to look like at the end. Additionally, pending litigation could shift that timeline. I'm not telling you this to suggest that Colorado doesn't matter anymore. I'm telling you this because Colorado illustrates how quickly things can change. And if you're focused on point-in-time compliance, that is not a viable strategy. I'm not telling you this to suggest that Colorado doesn't matter. It does. What I'm telling you this is to illustrate how quickly things can change. And to also talk about how if you are designing your governance model on a point-in-time compliance strategy based on a very specific set of rules, that's going to fall apart as soon as those rules change. You need something more robust that can stand the test of time and can stand a very rapidly changing regulatory environment. Um, Organizations that have navigated Colorado's evolution successfully are the ones that built governance based on a durable principles rather than their specific mechanics of what they thought was going to be the Colorado law. Um, Illinois is another good example. They require disclosure when AI influences employment decisions, and they prohibit certain uses of AI in hiring without human overview. Um, Texas's law, they ban specific harmful AI applications, and they require disclosure when government agencies or healthcare providers use AI in consumer-facing applications. Utah requires disclosure for certain AI and consumer applications. California has transparency requirements for frontier AI systems under the CCPA, which were regulations enacted in 2025. There's compliance obligations on businesses using automated decision-making technology to make significant decisions about consumers. There's a common thread through all of these state-specific rules and regulations, including Colorado's revised framework. They are disclosure, number one, human oversight, impact assessment, and accountability. If you build your governance model around those four pillars, you're going to be positioned to satisfy any current state landscape and any revisions that might occur as those laws and rules evolve. So your first layer was existing laws being applied to AI specifically. Your second layer was the patchwork of state AI laws. Your third layer is international laws. Specifically, right now, the EU AI Act is the most important for most operators in the AI space. If your organization has any EU nexus, and that means EU customers, EU employees, EU operations, if your data is using EU data, the EU AI Act is part of your regulatory reality, full stop. The EU AI Act is one of the most comprehensive AI regulatory schemes that's been enacted anywhere in the world as of today. It takes a tiered approach to AI. So there are applications that are prohibited outright. High-risk AI systems then also face significant compliance obligations, and general-purpose AI models face transparency and documentation requirements. Here's where things stand right now. Prohibited applications ban has been in force since February of 2025. If your organization uses AI for social scoring, for subliminal manipulation, or for certain biometric applications, those are already illegal in the EU. The GPAI model obligations, transparency and documentation requirements that apply to foundational model providers, that took effect in August of 2025. Transparency requirements for AI systems that interact directly with users take effect in August of 2026. The high-risk AI system obligations are a different story. So originally they were scheduled to apply in August of 2026. The EU institutions reached a provisional agreement in May of 2026 as part of what's called the Digital Omnibus on AI. And it deferred the high-risk reporting obligations for a period of time. Standalone high-risk systems now are looking at December of 2027 for compliance. High-risk AI that's embedded in regulated products, they have a compliance deadline of, it's been moved to August of 2028. So formal adoption of these amendments is fully expected by August of 2026. But I want to be precise about what this means. This is a deferral. This isn't a retreat. So the functional architecture of the Act, the risk-based framework, the governance structure, the core obligations are still in place. And I'll make the same observation about the EU Act that I made about Colorado. The fact that high risk deadlines have been pushed back is not permission to slow down your compliance. The organizations that use this deferral as time to build their compliance infrastructure are going to be way ahead of their competitors who sat on their hands and waited for this to get close. And if you sit on your hands and wait, you're likely going to be behind and scrambling, or you're going to not meet your obligation. So there's one practical point to consider with the EU AI Act, and that goes beyond just pure compliance and deadlines, right? The EU AI Act's documentation and governance requirements, risk assessments, technical documentation, human oversight mechanisms, data governance practices, all of those closely mirror what I would call great AI governance. That's what it looks like regardless of your regulatory obligations. Organizations that build EU AI Act compliance into their system. There's a practical point worth touching on that goes beyond pure compliance with respect to the EU AI Act. So, the EU AI Act's governance requirements, so things like risk assessments, technical documentation, human oversight mechanisms, and data governance practices, those all closely mirror what I would call great AI governance, regardless of what your regulatory obligations are. So, looking at those pillars and those sort of ideas of what should be in your governance is what kind of work you should be doing right now on your AI governance. Um, if your organization is building with an eye toward compliance with the EU AI Act, you're going to be in a position that your governance will satisfy any regulatory scheme, whether in the US, state, federal, or internationally. It's a defensible posture to build that way, not just for your company, but for your board of directors and their obligations, for your enterprise customers, or for any regulator who's going to come in and want to take a look at what your business is doing with their AI tools. All right, given everything I've just walked through, here's a sequenced framework of action for what your organization should be doing right now. Step one, start with a compliance gap audit. So, what does this mean? You need to spend time with all of your AI specific regulatory compliance and figure out where you stand with existing applicable laws. So, this means mapping all of your current AI applications, every tool, every vendor, every use case within your company. And you need to map that against the existing legal framework, anti-discrimination laws, privacy laws, consumer protection, securities laws, and any sector-specific regulation that you may have. So this audit is almost always the fastest and most revealing way to get at your current immediate need issues. Most organizations will discover 2 or 3 meaningful exposures that weren't on anyone's radar. And it gives you a baseline for deciding where to put your resources and what to prioritize when you're building your governance model. This is a starting point conversation. I have these conversations all the time with organizations when they come to me with their beginning AI governance questions. It's not because it's the only thing that matters, but it tells us where your immediate problems might be, and it gives us a baseline of where your company stands. So step two, you want to map your state law exposure based on where you actually operate. So once you have your baseline, you want to take a look at where you're actually operating, where your customers are located, where your employees are located, where your data resides, all of that, and then identify which state-specific laws apply to your actual use of the AI. It may be all of them, but it may be less than all of them. So we don't want to spend time looking at things that may or may not be relevant to you. Step three, you want to assess your EU AI Act exposure. If you have any EU nexus, you need to pay attention to that, and you need to figure out which risk category your particular AI use falls into. if you decide you have any prohibited uses under the EU AI Act, those are already banned, and you need to take care of that right away. You also need to think about your transparency requirements and your reporting obligations. If you have a high risk system, your obligations have been deferred, but that doesn't mean that you should ignore them right now. You should use this runway as time to get your disclosures prepared and ready to go. Even if your EU exposure is limited, it's always a good idea to look at their framework because it has a lot of great guidance that AI governance should be designed after. Step 4, you want to build adaptability. You don't want point-in-time compliance. This is the most important thing of this episode, and I'll spend a moment on it. So the regulatory landscape is going to continue to keep changing. The EU AI Act, that will be amended. State laws will change, be amended, added to, removed. Eventually, there will be a federal regulatory scheme for the US. If you build only based on today's requirements, your governance model is going to be obsolete within 18 months. The governance model that survives regulatory change is built around durable principles, documentation of your AI use, human oversight of consequential decisions, assessment of your AI risk before you deploy it, clear accountability of AI governance, and a process for monitoring, updating the model as the law evolves. Those principles not only satisfy the current regulatory landscape, but they satisfy any future regulations that we anticipate could be enacted down the road. They're also a defensible position for any audience that you may have, right? A regulator, they're going to make a defensible position for you. Your board of directors is going to love you because it will tell the board and your executive team exactly what they need to know about your company's AI usage and how it's being governed. It's going to even be useful if you get involved in litigation. What you did, being able to describe exactly what you did, how you did it, and how you made those decisions is going to put you in a much stronger position should you get involved in litigation. I want to close by the substantive part of this with an observation that I think is worth stating. So organizations that navigate the AI regulatory environment best over the next few years are going to be the ones not that track every single development on a day-to-day basis in real time. They're going to be the ones that build a compliance and governance system that's robust, that's based on overarching principles and are designed to absorb change as it comes. So it takes a different kind of legal and advisory relationship than just your traditional outside counsel, right? A traditional outside counsel, a company has a problem, they give it to their outside counsel addresses that particular problem at that particular moment in time. To have a proper governance system, you need to design it in a way that is robust enough to really be able to handle a rapidly changing environment. And unfortunately, that's what we're in right now with AI regulation. That's the kind of thing I do when I work with companies. I help them think about not only what's going on today, but how they can design a system that's robust enough to survive the future and what comes next. Here's the bottom line. The regulatory landscape is complicated and it's not going away. The executive order issued by the Trump administration is not actually making anything more simple, and it's certainly not doing it quickly. These things are going to take, even if there's a tension between state and federal law, it's going to take a long time, years to resolve. And in the meantime, you still have your compliance obligation. If you want to figure out where your company stands today and what exposure you might have, a compliance audit is a great starting point. You can contact me at vidarlaw.com. If that sounds useful, and we'll start there, no further obligation or commitment. And if you're a legal or compliance team and you want to start thinking about how to design a more robust system of governance, not just what the rules are, but how to build it into your organization and your ongoing workflows, that's a deeper conversation and one that I would welcome if you'd like to reach out to me. The governance system that we'll talk about in the next episode of this podcast is one that's going to be built to survive the regulatory changes. So your regulatory landscape isn't changing, neither should you. Thanks for watching. I hope you found this helpful. And if you'd like to talk more about designing a governance system, please reach out to me at vidarlaw.com. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.